Hello, everyone. This is Mark from the Gwinnett County Public Library, and I am here to tell you a little about the history of the Americans with Disabilities Act, the ADA, which is 31 years old this year. And this is part of the library's celebration of the International People with Disabilities Day, which is today, December 3rd. Your first question may be, what is it? The Americans with Disabilities Act. The ADA is considered a landmark piece of legislation. It was a 1990 Civil Rights Act that prohibits discrimination of people with disabilities. The act was signed on July 26, 1990 by President George H.W. Bush. It is a comprehensive civil rights declaration designed to provide universal accessibility to people with disabilities. It changed our society and our culture. Before we talk about what the Americans with Disability Act is, just talk a little about the history of this movement. This movement began to surge in the mid to late 20th century, and the movement got bigger and bigger as the years went on. Parents of children with disabilities began to fight against the exclusion and segregation of their children. Local groups were established to advocate for the rights of people with disabilities. And a profound and historic shift started to take place in disability public policy, modeled after previous laws which banned race, ethnic origin, and sex based on discrimination, began to take shape in the latter half of the 20th century. The disability rights movement adopted many of the strategies of the civil rights movement before it. It is made up of people who have worked for years organizing and attending protests, licking envelopes, sending out alerts, drafting legislation, speaking, testifying, negotiating, lobbying, filing lawsuits, and even being arrested. Without this movement, there would be no ADA. Probably the most important piece of legislation that came before the ADA was signed in 1990 is the 1973 Rehabilitation Act. It was the first significant piece of legislation to address disability rights. Before, each disability group was always seen as a separate group with differing needs. And Section 504 was particularly significant in this act because it changed the thinking on that. It recognized that people with disabilities as a group face similar discrimination in employment, education, and access to safety. The Rehabilitation Act of 1973 was put into law September 26, 1973, and Section 504 states, "No otherwise qualified handicapped individual in the United States shall, solely by reason of his handicap, be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." Nothing about us without us. This was the name of a book by James Charlton. The term sort of expresses the conviction of people with disabilities that they know what is best for them. And it's sort of become a mantra that has fueled the disability rights movement over the years. The slogan is also relevant beyond just people with disabilities. It communicates the idea that no policy should be decided by any representative without the full and direct participation of members of the groups affected by that policy. Another important occurrence, that happened right before the debate and signing of the Americans with Disabilities Act was called the Capitol Crawl. It occurred in 1990, shortly before the act was passed. Disability rights activists, over 1,000 of them, in March, marched from the White House to the U.S. Capitol to demand that Congress pass the Americans with Disabilities Act. When they got there, about 60 of them cast aside their wheelchairs and other mobility aids and crawled up the Capitol steps, chanting ADA now. This act became known as the Crawl-In. These people shed their crutches, wheelchairs, power chairs, and other assistive devices and immediately proceeded to crawl. It's seen by some as a very central act for encouraging the ADA into law, a physical demonstration of how inaccessible architecture impacts people with disabilities. Lots of info online about this profound protest. Before the act could be written and signed into law, the most important thing the government had to do was define disability. And it had to be a legal definition. Person is disabled if they have a physical or mental impairment that substantially limits one or more major life activity. They have a record of such an impairment, and they are regarded as having such an impairment. It is important to remember that in the context of the ADA, disability is a legal term rather than a medical one. Because it has a legal definition, the ADA's definition of disability can differ in how disability is defined in other laws, such as Social Security disability, retirement benefits. Within the law, there are 5 original titles to the ADA that guarantees equal opportunities in a number of areas. Title I, Employment. Title II, Federal, State, and Local Government Services. Title III, Public Places. Title IV, Telecommunications. And Title V, Miscellaneous Provisions. I thought we'd take a closer look at each one of these titles and what they mean for this significant bill. Title I, Employment. This title prohibits discrimination against qualified individuals in the following areas: the job application procedures, hiring and firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment. It applies to private employers with 15 or more employees, state and local governments, employment agencies, and labor unions. The charge for enforcing this title is the Department of Justice. Title II, Government. It applies to school district, municipal, city, or county and state level governments. Public transportation provided by public entities through regulations, including Amtrak, along with all other commuter authorities. And state and local public housing, housing assistance, and housing referrals. And the agencies charged with enforcing this title, the Department of Transportation and the Office of Fair Housing and Equal Opportunity. Title III, Public Places, applies to most places of lodging, recreation, transportation, education, dining, stores, care providers, places of public displays, and commercial facilities such as factories, warehouses, and office buildings. And the enforcement agency for this title, the Department of Transportation and the Department of Education. Title IV, Telecommunications. This applies to telecommunication services such as telephones, all telecommunications companies in the United States must take steps to ensure equivalent services for consumers with disabilities, such as assisted listening devices, telephone typewriters, volume-controlled telephones, sign language interpretation, closed captioning for federally funded public service announcements. And the enforcement agency tasked with this title, Federal Communications System, the FCC. And finally, Title V, Miscellaneous Provisions. This applies to provisions of the ADA as a whole and how they relate to other laws. Prohibition against retaliation, including threats, intimidation, interference, or coercion for those who exercise their rights. Clarification that the ADA does not override federal, state, or local laws that provide equal or greater protections. Provision of technical assistance to those who have rights or responsibilities under the ADA. Creation and maintenance of accessible design standards, and authorizing the use of settlement agreements and similar alternative means of dispute resolution. Reasonable accommodations. Pardon me. This is a very important phrase used in this law. A reasonable accommodation is any change to the application or hiring process, to the job, to the way the job is done, or the work environment that allows a person with a disability who is qualified for the job to perform the essential functions of that job and enjoy equal employment opportunities. Companies are expected to make reasonable accommodations for people with disabilities because of this law. Accommodations are considered reasonable if they do not create an undue hardship or a direct threat. Reasonable accommodations. Providing these will help make a company or business ADA compliant. Examples of reasonable accommodations include providing alternative communication and feedback formats, accessible parking, providing access to service animals, schedule modification, job restructuring, reorganization of the job, equipment changes, and reassignment. Some other reasonable accommodations fall under the category of auxiliary aids and services. Auxiliary aids include items, equipment, or services that assist in effective communication between a person who has a hearing, vision, or speech disability and a person who does not. Physical items include sign language interpreters, audio, and braille. But if the company doesn't provide these things, they can find other ways that satisfy these accommodations, such as someone who is blind and eating at a restaurant has a waiter who can help them read the menu and tell them things on the menu. That is accommodating someone with a disability. Another reasonable accommodation, service animals. Emotional support animals, therapy animals. The ADA provides explicit coverage for service animals, and a person with a disability that requires a service animal cannot be removed from the premises unless the animal is out of control and its owner cannot get it under control. The animal is a direct threat to people's health. These guidelines protect persons with disabilities and indemnify businesses from damages related to granting access to service animals on the premises. Of course, now there is some controversy about what constitutes a service animal, whether on airplanes or in a public space. and it's one that doesn't seem like it's going to die down soon. But for now, service animals are considered reasonable accommodations for companies and businesses. Undue hardship, another very important phrase in this law. An employer does not have to provide a reasonable accommodation that would cause an undue hardship to the employer. A determination of undue hardship should be based on several factors, including the nature and cost of the accommodation needed, financial resources of the facility making the reasonable accommodation, if the number of persons employed at this facility is fewer than 15, the impact of the accommodation on the operation of the facility, resources of the facility, the effect on expenses, and the nature and cost of the accommodation needed. There's much here about resources and finances, which play a big part in why some companies feel they cannot accommodate some of these ADA compliances. The one in the middle is pretty straightforward, though. 14 or fewer employees, you do not have to follow the law of the ADA. The General, Patricia Wright. There are a lot of people who made progress happen in the disability rights movement, particularly a lot of women. And one of the most powerful was Patricia Wright. She is widely acknowledged as the general who coordinated the campaign to enact the landmark ADA Act of 1990. Wright, who is legally blind, worked to establish acceptance of disability as a legitimate civil rights cause within the broad civil rights community, as well as within traditional disability service organizations. Ms. Wright was also the primary legislative and policy strategist for the disability civil rights community throughout both Democrat and Republican administrations, beginning with Ronald Reagan. Like many laws in this country, there was opposition to the Americans with Civil Disabilities Act. One of the most powerful groups opposing the act were the religious groups throughout the country. Religious opposition came from the idea that ADA legislation would label religious institutions public accommodations and thus would have required churches to make costly structural changes to ensure access for all. Religious groups also believed that the law was a threat to religious liberty, a, quote, improper intrusion of the federal government, end quote. Now, the U.S. courts have consistently agreed with religious groups on this claim, providing a variety of justifications. Here are two that have come down in specific rulings. Exempting religious entities from the ADA's equal access provisions allows them to design their facilities and perform their services in accordance with their religious tenets. Allowing the government to initiate ADA enforcement proceedings against religious entities would amount to an impermissible government interference with religion. And eventually, by the time the bill was signed, religious groups were exempt, and still are exempt, from the ADA law. More opposition came from the business community. The U.S. Chamber of Commerce argued that the costs of the ADA would be enormous and have a disastrous impact on many small and large businesses struggling to survive. The National Federation of Independent Businesses, an organization that lobbies for small businesses, called the ADA a disaster for small businesses. Pro-business conservative commenters also joined in the opposition, writing that the ADA was an expensive headache to millions, quote, that would not necessarily improve the lives of people with disabilities. Eventually, None of these arguments were accepted, and the business community did lose the battle to make themselves exempt from this law. There have been many amendments and updates, good and not so good, over the years since the signing in 1990. In 1998, the Supreme Court held that an individual who is HIV positive but asymptomatic has a disability within the meaning of the ADA and is entitled to the protections of the statute. A lot of this was made possible by a coordination between protest groups such as the Human Rights Campaign, ACT UP Coalition to Unleash Power, and the ACLU, the American Civil Liberties Union. Since the passage of the ADA, the U.S. Supreme Court has struggled with the legality of this law and often issued decisions that narrow its scope. In 2008, Congress demonstrated its disagreement with the court by passing the ADA Amendments Act of 2008, ADAAA, in order to revive more extensive definitions of disability than those used by the court. The ADAA states the definition of disability shall be construed in favor of broad coverage of individuals under this Act in the maximum extent permitted by this Act. It did broaden the definition of disability. It modified key terms of that definition, expanding the definition of major life activities. It redefined who is regarded as having a disability, modifies the regulatory definition of substantially limits, and specifies that disability that is episodic or in remission can substantially limit a major life activity. H.R. 620, ADA Education and Reform Act of 2017. This bill added a, quote, notice and cure clause to the ADA, effectively shifting the burden of compliance for public accommodations away from public establishments and onto the individual with the disability. For instance, someone who experiences discrimination in access to a public accommodation would have to notify the established owner, would have up to 60 days for the owner to respond to the complaint, and then 120 days before the complainant would be allowed to file a lawsuit. Supporters of this bill, which passed in the House of Representatives, characterized it as a measure aimed at discouraging frivolous lawsuits. Opponents see the bill as nothing less than an effort to undermine the ADA. Lawsuits, there are many because of the law, but I'm not sure it's the right reason to limit the law. Web content and accessibility. Remember we talked about telecommunications before. Well, as times change, so do the things we work with and how we live our lives. And the web is a new addition, or it should be a new addition to the ADA law. But there is no federal consensus on whether it is considered discrimination when public accommodations fail to provide auxiliary aids where necessary. The high courts in the U.S. have been wildly consistent in determining whether the ADA project access not just to brick and mortar public accommodations, but also to the websites and apps of these companies and businesses. But 508 of the Rehabilitation Act from 1973 does require federal department and agencies to ensure technology is accessible. Something you might be interested in seeing is a movie called Crib Camp. It is a 2020 documentary. It begins in 1971 at Camp Jened and focuses on campers who turned themselves into activists for the disability rights movement, and it follows their fight for accessibility legislation. It was critically acclaimed and presented at the 2020 Sundance Independent Film Festival, where it won Best Documentary, and it also received an Academy Award nomination last year for Best Documentary Feature. It is now available on Netflix, and it really is an inspiring movie. It was executive produced by Barack Obama and Michelle Obama. Speaking of President Obama, he spoke to the UN once about international disability rights, and he spoke of its legacy in very eloquent terms. The ADA was a formal acknowledgement that Americans with disabilities are Americans first, and they are entitled to the same rights and freedoms as everybody else. A right to belong and participate fully in the American experience, a right to dignity and respect in the workplace and beyond. The freedom to make of our lives what we will. President Obama said that at the 2009 UN Convention on the Rights of Persons with Disabilities Proclamation. There's lots of reading and studying and literature out there available for anybody that wants to know more about the ADA, all the way to the top, how one girl's fight for Americans with disabilities changed everything. This is a great book for kids, and it is about one of the participants of the Capitol Crawl that we spoke about earlier. Enabling Acts by Leonard J. Davis, the hidden story of how the ADA gave the largest U.S. minority its rights. And for more information, you can visit ada.gov. There's a lot of great information on the history, the current aspect and future of this law. And you can visit the Gwinnett County Public Library to learn more about it if you like. Well, once again, I'd like to thank you for joining us, helping us celebrate the International Day of Persons with Disabilities and the 31st anniversary of the Americans with Disabilities Act. Again, my name is Mark. I'm with the Gwinnett County Public Library, and I hope you enjoy the rest of your day.